Welcome to Divorces Schmidt, a family law series. In this episode, I will discuss the judgment of Judge Glass in Shams Alkaios, which is the first published parenting case determined on the basis of the 2023 amendments to Part 7 of the Family Law Act. Before I get into the topic for this episode, I have a few words about this series. Several colleagues have said kind things about it, and I've looked at the analytics on each platform where it's published. What I've learned from the analytics is that virtually all engagement with this series so far has been on LinkedIn. However, I've had several people tell me that they play the videos on LinkedIn just to listen to them while driving or doing other things. Others have commented that they don't like having to watch or listen to CPD content and would prefer to just read what I'm talking about. They've all seemed surprised when I told them that from the very beginning, this series has been available not only in video form on LinkedIn, Facebook, Instagram, and YouTube, and by the way, on YouTube it's in 4K and you can read the screenshots clearly, but it's also an audio-only podcast on all the big platforms like Spotify and Apple Podcasts. But the thing that nobody seemed to realize is that there are full write-ups of every episode on my website, which you can find at schmidt.law. Anyway, back to the topic at hand. As everyone who has anything to do with family law knows, the Parliament passed the Family Law Amendment Act 2023 last year, which had particular focus on Part 7 of the Family Law Act 1975. Since the first exposure draft of the bill was released, there has been much discussion about the effects of the amendments. I was on the record early with a view that the amendments were, for the most part, a simplification and rewording of the same concepts, aimed at making the provisions easier to understand for self-represented litigants, rather than a massive upheaval. Now, whether I was right or wrong, my views will forever be freely available online to haunt me in a 10 fireside chat with Jackie Campbell. The amendments took effect on the 6th of May 2024. That day, Judge Glass of the Federal Circuit and Family Court of Australia Division 2 in Melbourne commenced a 3-day parenting trial. No doubt many other judges did the same, but Judge Glass has the unique privilege of delivering the first published judgment applying the amended provisions. His Honour delivered judgment in Shams Alkaios on the 20th of May 2024. It was a fairly straightforward relocation matter where the children had been living with the father in Melbourne and the mother sought a change of residence for the children to live with her in Queensland. There's nothing extraordinary about the facts of the case, but it is the first and at the time of recording the only published decision based on the freshly amended Part 7. So how did Judge Glass consider and apply the new provisions? Are there drastic impacts as a result of the new simplified objects of Part 7? Does the absence of a presumption in favour of equal shared parental responsibility mean that sole decision-making orders will be the new normal? Have the Section 60cc best interest considerations changed everything? The first thing one sees when looking at the judgment is Order 1, which reads, "The parties make joint decisions in relation to all major long-term issues in relation to the children." This is the new equivalent to the old order for equal shared parental responsibility, but in language which makes it absolutely clear that the order is about decision-making and nothing else which might have been read into the term parental responsibility by someone not familiar with the law. Of course, absent from the judgment is any discussion of a presumption, as none exists anymore. Decision-making is now just another aspect of the discretionary assessment of best interests considerations. However, in determining the allocation of decision-making, after analysis of the best interest considerations, which I will discuss in a moment, Judge Glass referred to the, quote, encouragement prescribed by Section 61(c)(a), which provides the following. If it is safe to do so, and subject to any court orders, the parents of a child who is not yet 18 are encouraged A, to consult each other about major long-term issues in relation to the child, and B, in doing so, to have regard to the best interests of the child as the paramount consideration. Judge Glass noted that he was guided by the objects of Part 7 as found in Section 60(b), but did not otherwise refer to them. So the objects don't seem to make a big difference in his Honour's consideration. The new Section 60cc is much shorter and simpler than the old one. The old language of protecting children from harm has been replaced by a focus on the safety of not only the child, but also the child's carers. First up, of course, is paragraph A of subsection 2, arrangements which would promote the safety of the child and carers. Under this factor, Judge Glass traversed the history of the parenting arrangements, what is Honour termed as, quote, generalised assertions, unquote, by the mother about the father in relation to abuse and controlling behaviour, allegations of physical violence, and other allegations of family violence. His Honour also included in this part of the judgment discussion about what in this case was a lack of family violence orders. On my reading, there was nothing novel in the discussion. It encompassed the matters which His Honour would have discussed pursuant to the old Section 60cc 2 paragraph B and 3 paragraphs J and K. His Honour was ultimately not satisfied that the father had caused harm to the children and was therefore not satisfied that a change of residence was necessary to promote their safety. Next up is paragraph B of subsection 2, which is the views expressed by the child. In the familiar way, His Honour discussed the children's views as relayed by the family consultant. This is unsurprising, as the wording of the new paragraph B is a truncated version of the old paragraph A of subsection 3. Next up is paragraph C, which relates to developmental, psychological, emotional and cultural needs of the child. Here, His Honour turned his discussion to the family consultant's opinions about the care provided to the children in their primary residence and the support the children receive at home and at school. His Honour also referred to the family consultant's evidence about potential emotional distress which would be occasioned on the children by a move from their familiar environment and community to a new life in Queensland. Next, in relation to paragraph D, which is the capacity of each person who has or is proposed to have parental responsibility for the child to provide for the child's developmental, psychological, emotional and cultural needs. Judge Glass's discussion of this factor is reflective of the discussion one would have expected in relation to the old subsection 3 paragraph F. It has the usual themes of parental capacity and insight, child focus and support of the children's relationships with the other parent. Next is paragraph E of subsection 2, the benefit to the child of being able to have a relationship with the child's parents and other people who are significant to the child where it is safe to do so. Here, His Honour considered the nature of the children's relationships with each of the parents and other significant adults, ultimately determining that the children had strong and sound relationships with each parent, which could be sustained despite the geographical distances between them. Having found earlier that there was no risk to safety, the last 6 words of paragraph E, being where it is safe to do so, had no work to do in this case. In the absence of safety concerns, the new Section 60cc 2D appears to reflect the old 60cc 2A and 3B, C and D. Paragraph F of subsection 2 says, anything else relevant to the particular circumstances of the child. This is the new version of the old Section 60cc 3M catch-all provision. His Honour did not discuss any relevant matters here. No doubt we will see more and more judgments in the coming months, which will show us how various judges in all 3 courts, Division 1, Division 2 and the Family Court of Western Australia, are applying the new provisions at first instance. In time, we will get further clarification from the full court and eventually the High Court. Based on this first published judgment though, it looks like we may all be able to relax a little bit about the amendments, as nothing much seems to have changed. I'm Johannes Schmidt. Thank you for listening. I hope that this discussion has been of use to you. If you'd like to be notified as I release further episodes of Divorce with Schmidt, please follow me on your preferred social media platform, subscribe on YouTube, or subscribe on your favourite podcast platform.